Hello, everybody. Hi, and welcome. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And today I want to share with you today's topic, which is 3 ways to destroy a witness's credibility at the time of trial. You want to learn what this is about? Come join me for a few moments as I share with you some terrific information. Okay, so imagine this scenario. So now you've brought a lawsuit against somebody who is careless, causing you significant harm and injury. So let's say, for example, that this involves a claim against your doctor. Thanks so much for the thumbs up. I appreciate it. So let's say this involves a claim against your doctor, right? You believe that your doctor was careless, and as a result of his carelessness, caused you significant harm and injury. And now you bring a lawsuit against your doctor. Well, guess what? Now your case goes all the way to trial. You have to go through 2 or 3 years worth of discovery to get to the point of trial. You have to go through the whole litigation process. The doctor, on the other hand, turns around and says, hey, why are you suing me? I did nothing wrong here. I wasn't careless. Nothing I did caused or contributed to your injuries. And by the way, your injuries really are not as bad as you claim them to be. All right, so now you have a contested issue. You claim your doctor was careless. The doctor says, no, I wasn't. And now you've got a significant problem. David, nice to see you. Thanks for joining me this morning. So now you have a contested issue. So how do you resolve this issue? Well, ultimately, if the doctor refuses to consent to settle, if he doesn't want to enter into negotiations, now your case ultimately will go to trial. So what does that mean? It means that now you have an obligation to put on whatever witnesses, whatever testimony, whatever evidence you need in order to support your claim that you are more likely right than wrong, that what you are claiming is true. That's how you show that you're entitled to a verdict in your favor. And that's a very important point. The defense, on the other hand, will put on whatever testimony and evidence to support their defenses to argue that they did nothing wrong. So one of the key strategies by an attorney, hey, David, nice to see you. Okay, David, nice to see you. Today I'm talking about 3 different ways you can destroy a witness's credibility at trial. So thanks for joining me this morning, and I'm glad you're here because I'm talking about now a scenario where you brought a lawsuit, a civil lawsuit, against someone who you believe was careless, and that carelessness was a cause of your injury, and now the defense refuses to acknowledge or take responsibility for anything they did wrong, which means ultimately your case is going to trial. Thanks so much for the thumbs up. I love it, love it, love it, love it. That's great. The thumbs up are terrific. So now you have to get to trial. Once you're at trial, you have an obligation to show that you are more likely right than wrong. Awesome, awesome thumbs up. Love it. This is great. So what do? Well, a key agenda for any attorney who now is going after witnesses on the witness stand is to try and destroy their credibility. You have to try. Oh, I love those hearts. Those thumbs up are great. Thank you so much. You have to destroy a witness's credibility, or at least attempt to do that. Why? Because you want to show the jury. You want to explain to them that this witness, who now is testifying against you, may be less than credible, may be less than truthful. And the only way to do that, to show that this person cannot be trusted, is to go after their credibility. So let me go through with you 3 different ways. That's the topic of today's video. 3 different ways. There you go. 1, 2, 3. To go ahead and show that this witness's credibility is less than 100% stellar. Okay? The first one is, here we go. Let me get out my trusty notebook. The first one is using pretrial testimony. We call that deposition testimony. Now you should know a deposition is nothing more than a question and answer session that's given under oath in your attorney's office. But you should know something very important. It's pretrial testimony and carries the same exact weight as if you are testifying at trial. So even though there's no jury there, even though there's no judge in the room, there is a court reporter in the room to record all of the questions and all of the answers. Here we go. And once that happens, now, everything that you say in response to a question, that becomes your pretrial testimony. So now, if somebody asks you what happened, and now you tell them the answer, that becomes your testimony. So now, let's say 2 years, a year down the road, when your case goes to trial, and you are asked the same exact question. If you now give a different answer compared to what you gave a year earlier during your question and answer session in your attorney's office, guess what? Now you've got 2 different answers. You've got what appears to be contradictions. You said one thing a year ago. You said another thing right now in front of the jury at trial. That is a crucial way to show that you may be less than credible in front of the jury's eyes. Because remember, the jury was not there watching and listening and learning about the questions and answers during your pretrial testimony in your lawyer's office. Nor do they have the booklet, the transcript of all the questions that were asked and all the answers that you gave, right? Those questions and answers were they were transcribed and put into a booklet, and then you were asked to review that to make sure there were no typographical errors. But they don't know anything about that. All they know is that this attorney is getting up to cross-examine you, and guess what? Now you give an answer that triggers an alarm bell in the attorney's mind. So now he takes out this transcript, this booklet, and he says, hey, Mrs. Jones, isn't it true that you were questioned, that I questioned you 1 year ago in your attorney's office? Yes, that's true. And at that time, didn't you swear to tell the truth? Yes, I did. And at that time, when I asked you questions, you responded and gave me verbal answers. Isn't that true? Yes. And there was a court reporter there to record all of your answers. Isn't that right? Yes. And she put all of your answers into this booklet. Isn't that right? Yes. And afterwards, your attorney sent you a copy of this booklet. True? Yes. And you were supposed to read it over to make sure that there were no errors in that. Correct? Yes. And you did that, didn't you? Yes, I did. And you were told that if you had to make corrections, to do it on a separate piece of paper, to sign that paper, right? Yes. And you were supposed to sign the booklet too, isn't that right? Yes. And you did that too, right? Excellent. Now this is the booklet that you sent back to your attorney. You see here? Here, let me show you the signature line right there. Isn't that your signature? Yes. Okay. So what am I doing? I'm setting this witness up to show and highlight the contradiction that's coming in just a moment. I'm establishing for the jury the fact that she gave these answers to these questions a year earlier. And now I'm going to direct her to the exact line and the exact question. Hey, Mrs. Jones, isn't it true that on page 18, line 7, you were asked this question? Yes. And now you gave this answer in response to that question. Isn't that true? Yes. Now that's going to be the same exact question that I have just asked her at trial. And now she's given a different answer. But I'll tell you something important. I am not going to ask her why her answer is different from a year ago compared to right now. You want to know why not? Let me just straighten my mic. It's because you never, ever, on cross-examination, ask a witness why. You never want to ask a witness, why is your answer different? Do you want to know why? It's because, this is really important, it's because the moment I ask why, all of a sudden they're going to give the jury a long-winded answer that's going to justify and explain why she gave one answer a year earlier during her pretrial testimony and a different answer now in front of this jury. So I never, ever, Andy, nice to see you. Welcome. Come join us. So I never, ever want to go ahead and give the witness that opportunity to go ahead and explain anything during the course of this question, during this course of cross-examination. And that is one key strategy. That's a very important strategy of how to destroy a witness's credibility at the time of trial, to show contradictions between what she said a year earlier during her pretrial testimony and what she said now in front of the jury. That's a key important point. All right, let's get to point number 2. Here's the second way that we can go ahead and try and destroy a witness's credibility. And again, I'm going to refer to my handy-dandy notebook, because when I'm doing these videos, it's critical to make notes so that I don't forget the key strategies I want to get across in these videos to help you understand how these types of cases work here in New York. All right, the second way to destroy a witness's credibility is to show that they told a little white lie. Now, that's very interesting, isn't it? How can a little white lie destroy someone's credibility? Very, very simply. And I'm going to show you in a couple of steps. So let's say, for example, that you were convicted of a crime many years ago. And let's say you did something really stupid. And now you paid a price for it. Not now, but then you paid a price for it. And now, many years later, you got treatment by a doctor, and he was careless, and he caused you significant harm and injury. Well, guess what? You now bring a lawsuit against your doctor. And the defense turns around, and during the course of pretrial questioning, they turn around and say, hey, Mrs. Jones, isn't it true? No, they're going to ask you this way. Mrs. Jones, have you ever been convicted of a crime? And you're thinking, shoot, you know what? I have been, but I'm afraid to tell this lawyer the answer to that question because I'm afraid of what he's going to think of me. I don't want him to think poorly of me. It'll affect my case. So you decide to conceal that information from him during his questioning. Well, you say, of course not. I've never been convicted of anything. And now the attorney continues on and asks you lots of other questions. Well, you think nothing of that. And by the way, you had never told your attorney during his preparation session of you about the questions that you were going to be asked. You never mentioned him, you never mentioned to him the fact that you had been convicted in the past. So now that's a little twist. It's going to be a problem that's going to come back and bite you on the butt, and I'll tell you exactly how. So this little, what you conceive to be, hey, Kimberly, nice to join. Thanks for joining us. Thank you so much for coming. Today we're talking about 3 different ways to destroy a witness's credibility at trial. The first way was to show contradictions between pretrial testimony during a question and answer session in a civil lawsuit in New York compared to the testimony that she's giving at the time of trial. So that's really important. We're now on to number 2. And that is, hey, Kimberly, hi, how are you? Now we're talking about number 2, the second way, and that is telling a little white lie. Now, you may say, what's the big deal? You tell a little white lie, and guess what? Hey, thanks so much for the thumbs up. That little lie, Michael, nice to see you. How are you? Just to recap, we're talking about 3 different ways to show, not to show, 3 different ways to go ahead and expose someone's credibility, actually to destroy their credibility at trial. The first way is with pretrial testimony to show the contradiction between what somebody said during the course of pretrial testimony, known as a deposition, and what they said a year or 2 later at the time of trial. That's really important, using a deposition transcript. The second one that we're up to now is, let me go back again, it is telling a little white lie. And a lot of people think, you know what, what's the big deal? It's a little white lie, nobody's ever going to find out, nobody's ever going to know, so what's the big deal? I'll tell you what the big deal is. So let's say, for example, again, I'm going back to the example I used just a moment ago, that you had been convicted of a crime in your past when you were young. You did something stupid, and you paid a price for it. But now, 15, 20 years later, now you suffer harm and injury because of someone else's carelessness. And you decide to bring a lawsuit against them. Might be a careless driver. Maybe it was a careless doctor, right? And during the course of your pretrial question and answer session, the defense attorney has an opportunity to ask you a question. He asks you lots of questions for hours. Now, one of the questions they're going to ask you is, hey, Mrs. Jones, have you ever been convicted of a crime? And you're thinking, you know what? What does that have to do from 20 years earlier, have to do with my claim against my doctor now? And the reality is, it has nothing whatsoever to do with it. But you feel, you know what? It's got nothing to do with it. I'm just not going to tell anybody about it. Nobody's ever going to find out. Well, guess what? So you decide, hey, no, I've never been convicted of a crime. And now the defense attorney moves on and continues asking you lots of other questions. What you just did is you told a simple little lie, thinking or believing that no one would ever find out. Well, guess what? You are 100% incorrect. Objection. That's improper. What you've done now is you've literally destroyed your entire case by telling that little white lie. And let me tell you why. Hey, Josh, nice to see you. Thanks for joining us. Josh, we're talking about 3 different ways to destroy a witness's credibility. Okay, we're up to number 2, which is telling a little white lie. So we're using the example of someone who was convicted of a crime 20 years earlier and now brings a lawsuit against a doctor or careless driver. And now the defense attorney, during pretrial questioning, goes ahead and says, hey, Mrs. Jones, have you ever been convicted of a crime? And Mrs. Jones says, hey, you know what? No, I haven't. What she's done is she's told a little white lie. And let me show you how that little white lie can come back to bite you in the butt. So now, this defense attorney, by the way, he knew exactly whether or not you've been convicted. Kimberly, I love your videos. I learned so much. I'd like to share your videos on my business page if you don't mind. Absolutely. Can I interview you on why an attorney needs to have a legal nurse and your opinion? Absolutely. Would love to do that at another time. Reach out to me, send me a private message, and I'll be happy to do that. And feel free to share these videos with people on your pages, because I think they really need to understand how these types of cases work. So let's get back, and thanks for that information. So let's get back to the information I was just talking about. The defense lawyer, when he's questioning you during your pretrial question and answer session, known as a deposition, he already has the information. Hey, Jesse, nice to see you. Thanks for joining. Kimberly, you're welcome. He already has that information about whether or not you were convicted. But he's testing you. He wants to see whether or not you are honest enough to answer that question. So now, by the way, you didn't tell your attorney about the fact that you had been convicted. And your attorney, hey, Jesse, thank you so much. Love your info and your videos. Love the thumbs up. Thank you. That's great. So you did a disservice to your attorney because you didn't disclose this information to him, nor did he bother to do a proper investigation of you at some point after you started your case. Thank you. I love those hearts. Love them. They're fantastic. Oh, this is great. This is great. And so what happens now is that your attorney is at a significant disadvantage because now he's going to get blindsided. He's not going to get blindsided right now during pretrial testimony. Instead, it's going to happen a year down the road at trial. And now you're going to be your credibility is over. You don't realize it. That little white lie is going to destroy you and your case. Love it, love it, love it. Love those thumbs up. Keep them coming. Love those hearts. This is beautiful. This is great. And while you're doing that, I'm going to take an unsponsored water break from Aquafina. They're not paying me. If they'd like to, they're more than welcome to. And by the way, guys, if you know someone who'd like to sponsor this video, reach out to me, send me a private message, and keep sending those hearts. This is great. Okay, so now let me show you exactly how to destroy a witness's credibility at trial when your witness or somebody has told a little white lie. So here's what's going to happen. Now, you're up on the witness stand. You're testifying on direct examination. And your attorney is asking you lots of questions. Finally, he finishes. And it's now time for the defense lawyer to get up and now begin cross-examining you. And he's asking you a whole series of nice questions that are not too bad. And then all of a sudden he says, hey, Mrs. Jones, have you ever been convicted of a crime? And you say, no. And now the attorney pulls out a document and he says, Your Honor, at this time I offer this document into evidence and I ask the court to take judicial notice of it. And he says, show it to your adversary. Now I hand a copy to my adversary and he looks at it and you just see him go white. Or he jumps up and he tries to make an objection. And what is this document? This is a document confirming the fact that you were, number one, arrested and charged with a crime. Number two, that you either took a verdict, again, and now you were found guilty, or you took a plea. And now this document is also going to show what your sentence was. Did you serve time? Where were you in prison? And now he's asking the judge to take notice of the fact that this is an official legal document, and he wants the judge to be aware of it. And once the judge becomes aware of it and now says, yes, the court will take judicial notice of that, what that means is the court recognizes the validity of this document and now accepts the truth of the matter, of everything contained in here. Now all he has to do is show it to the jury. Okay? He doesn't have to say anything else if he doesn't want to, but he's going to. He's going to say, hey, Mrs. Jones, your name is Jane Jones. Isn't that true? Yes. And your birth date is January 1st, 1942. Isn't that true? Yes. And isn't it true that on December 2nd, 1999, you were arrested for criminal possession of drugs, for example? And now there's going to be a lot of hemming and hawing, objecting, a lot of drama going on right now, right? All he's doing is reading from the document that the court has recognized to be authentic. Well, isn't it true that after a trial, you were found guilty of possession of this of this drug? And now the person has to admit it. Okay, but now, you just told us a few moments ago that you had never been convicted of a crime. Isn't that true? Yes. Oh, but let me explain. No. You just told us a few moments ago that you had never been convicted of a crime. This indicates that you were convicted of a crime. True? Yes. And in fact, a year ago, when I asked you the question during your pretrial question and answer session, I asked you the same question. Isn't that true? In fact, the question and answer session that took place on July 5th, right? A year ago, I asked you the same question at line 22, page 22, line 7. Mrs. Jones, have you ever been convicted of a crime? Answer, no. I asked you that question, you gave that answer. Isn't that true? Yes. So now, what have I done? I have shown in just a few simple steps that this witness lied. That she lied. It doesn't matter why she lied, but I've now shown the fact that she has lied. And now the jury can take into consideration the fact that she has lied. Excuse me, one second. Okay, so that's the second way in which we can go ahead and destroy the witness's credibility, by showing that they told a little white lie. Now, you might not think it's a big deal, But it is. Telling a little white lie can destroy everything. You want to know why? At the end of the trial, the judge gives the jury legal instructions that tells them exactly what they need to know about the law in that particular case. And there is one key instruction that the judge tells them about credibility. And it has a fancy legal term. It's called falsus in uno. And what that really means is, listen, hey, jury, if you believe that a witness has lied about one little thing, you have the right to disregard all of their testimony. All of it. You can accept part of it, you can disregard some of it, you can disregard all of it. But you have that legal right if you find that a witness has testified falsely about one thing, you can find that they testified falsely about everything. That is so powerful. That is so unbelievably powerful. So that's a key strategy on destroying a witness's credibility. Now, does that happen often? Where we get somebody who does that happen often where we get a witness who hides the fact that they were convicted? No, that doesn't happen often, but it does happen once in a blue moon. And I just wanted to use that to illustrate to you the fact that this is another key way to destroy a witness's credibility. So I was using the conviction as a way to highlight and illustrate this little white lie. And you can use any type of little white lie to show that. Now, you won't always have the documents showing exactly what they were convicted of, but once you can show the contradictions, oh my goodness, you can basically destroy their credibility and show the jury that this witness is not to be believed. So the next one, I'm going back to my trusty notebook. I wrote down, they lied about a prior criminal conviction. Well, that is true, but instead of a prior criminal conviction, let's turn it around, because I already used that example in number 2. So instead, let's say that the witness has forgotten something during the course of being asked questions during her pretrial testimony. Hey, Mrs. Jones, isn't it true that when you spoke to my client, Dr. Gold, you told him X, Y, and Z? Well, I don't remember. Isn't it true that Dr. Gold gave you this piece of paper to review called an informed consent sheet before going ahead and agreeing to have surgery? I don't remember. Mrs. Jones, isn't this your signature that appears on the bottom? Well, it appears to be, but I don't ever remember signing that. Okay, so now what have I done? Now I've gotten the witness to lock herself into an answer, a series of answers, where she's now told me something about what she does or doesn't remember. So now, a year later, we're at trial, and I ask her on cross-examination the same questions. Remember, the jury doesn't know anything about these questions. They don't know what's contained in this booklet. They don't know what questions were asked and what answers she gave. So now I'm asking these questions. And I said, hey, Mrs. Jones, do you remember this document? Oh, yes, of course I do. Really? Do you remember reading this document? Absolutely. Now the alarm bells are going off in my head. Why? Because she's saying something different than what she said a year earlier. Mrs. Jones, do you remember signing this? Of course I do. What? She told me a year earlier when I questioned her that she had no memory of the conversation between the doctor and her about the consent, about the doctor telling her about all the risks and benefits and alternatives to this particular surgery. And now, all of a sudden, a year later, she remembers all this stuff? Now, remember what I said earlier? You never ask a witness why. Why is their answer different? Or why all of a sudden do you remember something now? But instead, I now have to show to the jury that this witness has lied or conveniently changed her testimony, or some attorneys will say that she's being less than truthful or untruthful, and now I have to show them how. And it goes back to using her sworn testimony that she gave during her pretrial question and answer session. And how do we do that again? Well, Mrs. Jones, isn't it true that on June 1st, I came into your attorney's office and I had a chance to question you? Isn't that true? Yes. And there was no judge there, right? No. And there was no jury there, right? No. But there was a court reporter there, right? Yes. And the court reporter was there and your attorney was there, isn't that right? Yes. And you had a chance to speak to your attorney before we began that morning, isn't that right? Yes. In fact, your attorney prepared you for the types of questions I was likely going to ask you. Isn't that true? Yes. And now it's time for another unscheduled, unsponsored water break by Aquafina. All right. So again, we're using pretrial testimony, pretrial deposition testimony to go ahead and show that the witness is being less than truthful. So what are we doing? How are we doing it? I'm locking the witness into her testimony to show to the jury that she gave answers to certain questions. And this is what she said a year earlier. No, I don't remember. No, I don't remember. No, that doesn't look like mine. Maybe it is my signature. I'm not sure. And now, what did she say here at trial? She said, yes, I remember. Yes, I signed this. Yes, I talked to the doctor. Here's what I said. Really? Well, guess what? Obviously, there are contradictions. Obviously, there are discrepancies. There's differences between what she said a year earlier and now what she's saying at trial. And now my job, the attorney's job, is to show and highlight to the jury those discrepancies. I don't care about the reasons why. I'm going to imply to the jury that the only reason why the answers are different now is because she's had time to think about those answers. She's had time to think about the strategies with her attorney that will benefit her in giving her the best outcome by what she says at trial. And that's going to be a key point during closing arguments. So remember, I'm going to highlight the fact that there are inconsistencies, and then I'm going to drop it and move on. You'll find that the best trial lawyers do not go ahead and beat the witness over the... Hey, thank you so much for those hearts. Love them. Keep them coming. Yes, yes, yes. Love those thumbs up. Thank you. This is fantastic. So we don't beat them up over the head right then and there while they're on the witness stand. Otherwise, we're going to look like a bad guy. The jury won't understand why we're beating up the witness. Thank you so much for those hearts and those thumbs up. Yes, yes, yes. Excellent. So instead, I wait till the witness is off the witness stand. I wait till closing arguments. And now, during closing arguments, I will then highlight to the jury each and every one of those inconsistencies. And then I'll ask them, how can you believe a witness who's now told you a little white lie? How can you believe a witness who's told you the following inconsistencies? Obviously, they're trying to hide something. Obviously, they're trying to manipulate you. And now, I can imply all sorts of things, and the jury will come to their own conclusion. And the judge, remember, one of the instructions that he'll tell them about is falsus in uno. If you find that a witness has lied about one thing, you may find that they have lied about other things. Well, that's it for today. Oh, thank you so much. Keep them coming. Yes, hearts, thumbs up. Beautiful, beautiful, beautiful. Share this video with your friends on Facebook. Share them with your family members. Let them see and understand how these types of cases work here in New York. Well, that's it for a beautiful Saturday morning today. I'm so glad you were able to join me on this Facebook Live video. And by the way, if you're watching this in the replay, then hopefully you're searching for information, and this has provided you with a great deal of information to help you understand how these types of cases work. And if your matter happened here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's great video. I'm Gerry Oginski. Thanks so much for joining me, and thanks for those hearts and thumbs up. They've been wonderful. Keep them coming. Bye-bye, everybody.